apply to her. And that's the very reason why, in a particular matter, you've heard about Prima facie determination. So if you read the original text of the Constitution, you don't find that provision when it comes to the removal of the Chief Justice. But it took a citizen of the land to take the matter to the Supreme Court somewhere in 2005 for the court to read into the provisions in 146 that the Chief Justice, being a judge for that matter, is also entitled to have that provision relating to prima facie determination. And in the Adane case, the Supreme Court made it clear that the president will have to make the prima facie determination in consultation with the Council of State. I think when the president received this petition, he decided to forward it. I'm not part of the presidency to the Council of State. Now, the question that's coming up is whether a prima facie determination can be made without notifying the person whose conduct in court is being questioned in the petition. So that's the essence of this particular suit that we all read. But looking at the Constitution, you ought to say that there's nowhere written in the Constitution that the subject of the investigation should be notified. But what has been the practice? I mean, the current administration has been in office before. There are other administrations that have been in office, and I think we have to leave the Supreme Court to determine whether, upon a careful reading of Article 146 and other relevant provisions, especially Article 23, 296, and 7 of the Constitution, before the president can consult the Council of State to make that prima facie determination, the PJ ought to be notified.
Okay. Again, some education here. Until a prima facie is determined, what then will the Supreme Court judge or the judge, what would he or she be responding to? Just the petition?
Two things. Notifying her that 3 petitions have been filed against you and that is being submitted to the Council of State for a determination of whether there's a prima facie case. And secondly, that from the principal point of view, also asking her to provide her comments relative to the petition that has been filed against her. And that's the crux of the case of the plaintiff that the Supreme Court is going to determine.
Okay. So, for example, if he or she responds to the petition and agrees to whatever allegations that the Constitution actually provides that these petitioners have raised, then there will be no need for the prima facie, or it is when he or she is saying otherwise that we can proceed to the next stage?
In terms of the prima facie, even if the person is notified and she admits, the Constitution has not made a provision that the process must be truncated. So we have to set up a committee, for the committee, 5-member committee, to go into the petition. And so it's not about whether the person is admitting or denying. The provision must be triggered from the start up to the end of that particular proceeding.
Please hang it there for me. I'd like to engage a private legal practitioner, Martin Pebu. I thank you for joining us this afternoon. I am certain that you may have seen the reliefs that Ekwasefa is seeking from the Supreme Court. And again, you may have seen the reaction from Thaddeus Story. He's been raising some questions. But on the face of it, has the president in any way erred, especially according to 146 or any other provision at all in the Constitution? Do I have... Oh, forgive me. I'll try and see if I can reconnect to Martin Pebu, but I'll go back to Mr. Tiayebo again and find out, well, maybe this gentleman, as I spoke to you this afternoon, you mentioned that we don't know the information that is available to him. Otherwise, then my question will be, the entire process with the learning that should be done in camera, at what stage then do we as a people or the public or this gentleman who is a citizen, which is why he's seeking this release in court, would he know that the Chief Justice has been notified or not?
No, in terms of the camera hearing, in-camera hearing, it is about the content of the petition and the hearing of that petition.
Okay.
That's what's covered. So the content and then the hearing. In any event, I think it's now settled legally that even if the petition is made available to the public, it does not vitiate the proceedings related to the removal of a person from office as a judge.
But at the moment, would it mean that until the president is seeking a response or a reaction from the Chief Justice, he or she cannot elect himself or herself to want to react to it in any way at all?
If the relief as claimed by the plaintiff are sustained by the Supreme Court, then that is the meaning. It means that the current president and future presidents will have to abide by such a decision.
Okay. Please, again, hang in there for me. I'd like to engage Mr. Martin Kpebu. Thank you for reconnecting with us. Has the president in any way, procedurally, erred in any way, looking at it with the face of 146 or any other provision in the Constitution? Mr. Kpebu, kindly unmute.
Yes. All right. So I said I don't see any breach of the law by the president. Not at all. You see, there are some parts of the process that we are mixing up. Let's understand the process is in two stages. The first part is that when the president receives it, that's the petition for the removal. The president, in consultation with the Council of State, must make a prima facie determination. It just simply means the president should look at it and see if there is any basis for the tribunal to be set up. So contrary to what I heard Senior Chieftaincy submit, the setting up of the 5-member tribunal is not automatic. The prima facie determination must first be made. Now, in order to make that prima facie determination, you don't always need the response of the Chief Justice, or if it's any other justice of the Supreme Court or Superior Court. But in this case, I'll limit to the Chief Justice. So let me explain. Assuming that, please, what's your name again?
MFR.
Hello?
Mr. Kpebu, my name is MFR.
MFR. Assuming you are Chief Justice, so Chief Justice MFR, and then let's say that Kaloni is President of Ghana. So Mr. Chieftaincy makes a petition against MFR, the Chief Justice. Kaloni is President. He receives it. Now, MFR has not signed the petition. So you wrote your name, but you didn't sign. So Kaloni looks at it and thinks that this thing that is not signed, I want to dismiss it, because once MFR has not signed, how will we know that MFR is truly coming from Chieftaincy? It's Chieftaincy who is making the claim. So based on this, you don't need the response of MFR's Chief Justice. Mr. Chieftaincy's petition can be dismissed by the president consulting the Council of State. It's not necessary. Number two, it's also possible that even MFR would sign but doesn't write her name. In that case, it's even worse. We don't even know the name of the person making the petition, right? In that case, the president, in consultation with the Council of State, can dismiss it without asking the Chief Justice to answer. So you see that many other mistakes can be made. Assuming the president receives a petition, which is just full of insults, invectives, vitriol, doesn't say much, but just keeps insulting, rambling over, doesn't make sense, too many typographical errors, is incoherent. How are you going to give that to the MFR as Chief Justice to respond? No. So the president will consult the Council of State and say, listen, I've dismissed it. So I think that we shouldn't run ahead of ourselves. What we should watch is that what the president cannot generally do is that if they find there is some merit in the petition, they cannot say Chief Justice Tokodo should go before the tribunal, the 5-member panel. That's the stage 2, if they've not heard from her. So that is the only one that would be a breach. But as for receiving the petition, the president must peruse it. If he has any concerns that he thinks makes the petition defective, he will consult the Council of State. I think this petition is defective in this respect. I'm going to dismiss it. What do you think? If they agree, it's dismissed. You don't need MFR as Chief Justice to respond. Please. And
so this performance of the president, is it discretionary, or there's a law that allows him to say, well, on the face of it, I just want to forward it to the Council of State so that they help me determine a prima facie case? Or I think that even before the determination, I want to engage the Chief Justice and say, well, there are 3 petitions against you. What do you say? Is it discretionary, or the interpretation of the law amounts to this?
It's the interpretation of the law.
Okay.
It's the interpretation of the law, because prima facie means that the accuser has said something. So you can look at what the accuser alone has said, and you can dismiss it outright without asking the respondent, in this case, the Chief Justice, to respond. So even if we understand the meaning of it, and Sanselade Ayanini has written a beautiful article on it. You Google, you find it online. Beautiful, because he did the Shraj case, Loretta Lamte. You know, at that time, other people who sent in their petitions, they wrote and didn't write well. So Chief Justice Georgina would dismiss those petitions without even asking the Shraj boss to respond, because those other petitions were not good. Okay. So she threw them out. It is the one Samson Ladi Ayanini, the host of Newsfile and lawyer, wrote that was taken in and eventually led to that. There are many other examples that we could give. Even the word, let's all understand, prima facie, it means that you, the one bringing in the petition, if you don't write it well enough and it's defective, the president can consult the Council of State and dismiss it without asking Chief Justice to. So we are running ahead of ourselves when nobody has seen the petition. So let the president consult.
When the Chief Justice responds or is engaged on this, will it also be done privately? Will the public see it? What does it mean when they say the process is done in camera? Good.
So this is what is going to happen. When the president finishes consulting the Council of State and he thinks he will dismiss it, he will give a ruling and it will be published. Remember, on the 3rd of January, when Ekufuado did the one, you know, Professor Kwekua Asare, properly called Azar, he sent a petition that Tokonu, Chief Justice, be removed. When Ekufuado finished the process, he published his ruling. So it's going to come out. So it's not going to be secretive. And then let's also add, maybe to obviate such lawsuits. That's why in the Frank Ejechu case, the Supreme Court said that there should be rules, proper rules should be drawn out, fleshed out, so that it can avoid some of these things. But trust me, the president and the Council of State can look at this thing first to determine if it's proper before they will send it to Chief Justice Tokonu. If they think it's not proper, they can dismiss it and not ask Tokonu to respond. Please.
Okay.
Yes.
Please stay with me. I'll come back to you. And when I come to you, I'll be finding out from you the constitution of the tribunal, as it will be by the Council of State in consultation with the president again, whether there is any conflict of interest in there. So please stay with me. But on phone, I'm joined by Sam Okujeto, former chairman for the Council of State. And I'd like to engage you on this because of your role and your performance in the Council of State over the years. This application, this petition, and a citizen, for that matter, a member of parliament, going to the Supreme Court to seek this particular release, is the whole process coming to you as a surprise? And if not, why?
Well, you're asking an interesting question. The petition has been submitted to the former president on that same issue. It was referred to the Council of State. The council decided that there was no prima facie case, that indeed the person who wrote the petition doesn't seem to understand the whole process of the judicial administration and the powers which are given to the Chief Justice. Unfortunately, that person